What is the Springboard Doctrine in breach of confidence, and how does it apply? Let's begin by discussing what breach of confidence is. Generally speaking, in Australia, in an action for breach of confidence, a plaintiff needs to satisfy three main elements for relief to be available. The three elements were set out in the case of Coco and A.N. Clark Engineers Limited by Justice McGarry. Justice McGarry stated that for an action for breach of confidence to succeed, firstly, the information must have the necessary quality of confidence about it. That is, the information must not be in the public domain. Secondly, the information must have been communicated in circumstances that implied an obligation of confidence. And thirdly, there must have been an unauthorized use or threatened use of the information. There are a few remedies for an action for breach of confidence, such as an injunction, delivery up, account of profits, a constructive trust, equitable damages, and compensation. Of particular note is the Springboard Doctrine. The first time the term springboard, at least within the Australian judicial context, was used was in the 1967 case of Terrapin Limited and Builder Supply Company, Hayes, where Justice Roxburgh stated that a person who has acquired confidential information is not permitted to use that information as a springboard in a manner detrimental to the person who communicated it. Justice Roxburgh went on further to state that the confidant should be placed under a special disability to ensure that he does not get an unfair start. The Springboard Doctrine is the principle in an action for breach of confidence that prohibits a recipient of confidential information, the defendant, from using that confidential information as a springboard for activities in a manner detrimental to the plaintiff. Practically speaking, the Springboard Doctrine permits the award of a temporary injunction in breach of confidence cases. The rationale behind the doctrine is that it is unconscionable for a confidant to be able to take advantage of their wrongdoing, that is, their unauthorized use of confidential information to acquire a head start on other competitors. A few points should be highlighted with respect to the Springboard Doctrine. Firstly, it was stated in Saltman Engineering Company Limited and Campbell Engineering that it is not a defense to breach of confidence to state that with sufficient time, labor, and expense, any member of the public could have acquired the correct process or combination of processes. This was confirmed in the case of Mentz and Milenkovic in 1973. Secondly, in AB Consolidated Limited and Europe Strength Food Company, it was held that simplicity is not a defense either. Just because a confidential process or combination of processes are simple will not prevent their protection. Thirdly, as was held in Dart Industries Incorporated and David Breyer Associates, modification of confidential designs is still considered to be a breach of confidential information. Justice Goldberg went on to state that a person must proceed through an independent design sequence and not use confidential information as a springboard to jump through that sequence. I mentioned before that the Springboard Doctrine permits only a temporary injunction, but how long is temporary? The simple answer is that the injunction will remain for the duration of the springboard or head start. In International Tools Limited and Collar, this was taken to mean that it will last for as long as it would take a member of the public to reproduce the information, considering the factors of labor, time, and expense. Thus, the exact duration will obviously vary with each particular case, but one thing is for certain, that is, that it will be for a limited duration, as was held in Harrison and Project and Design Company Redcar Limited, Terrapin Limited and Builder Supply Company Hayes, and Potters Ballatini Limited and Weston Baker,